The Renters' Rights Act is now in force, and it has changed the rules about tenant notices to quit. And this is the term that's used when tenants write to their landlords to say that they want to end the tenancy. The Renters' Rights Act has made it a lot easier for tenants to end a tenancy, but the rules are a bit tricky when it comes to timing. And in this video, I go through the ins and outs of what tenants need to do if they wish to end a tenancy validly, including what goes into a notice to quit, the rules about timing, and what happens when a sharer wants to leave and the others don't, and also what a landlord should do when they receive a notice to quit. I'm Suzanne Smith, lawyer turned landlord, and I run the Independent Landlord website and this YouTube channel to bring reliable information to everyone involved in renting in England. I'm also the author of the best-selling book, The Good Landlord Handbook, which you can buy on Amazon. There's a link below. There's a written version of this video on my blog, theindependentlandlord.com/NTQ. Right. Let's get started. What is a notice to quit? Well, a notice to quit is a letter, email, or even a text message that a tenant sends to the landlord to give notice that they want to end the tenancy agreement. This is also called giving notice or serving notice. And since the 1st of May 2026, tenants can serve this notice to quit whenever they like. They don't have to wait until the fixed term was due to end because they all ended on the 1st of May. How much notice does a tenant need to give to end a tenancy? Well, under the rules introduced by the Renters' Rights Act, a tenant needs to give at least 2 months written notice to end an assured periodic tenancy. That's what assured short-hold tenancies became, and it's now the new default tenancy. And the notice needs to expire so that the tenancy ends on a day when the rent is due or the day before, to use the wording from the government guidance. So this 2-month period acts as a cap. And a landlord can't include a binding clause in a tenancy agreement that says notice needs to be more than 2 months, ending at the end of a rent period or the first day of a rent period. But they can agree to a shorter notice period. What if the tenancy agreement states that the notice period is 1 month? Well, this is such a popular question because it was very common for ASTs to have clauses in them saying tenants could serve 1 month's notice to quit when outside of a fixed term. So if your AST, your old assured short-hold tenancy, says that, and that has now become an APT, an assured periodic tenancy, then that clause survives the Renters' Rights Act, as it's an agreement by the landlord to a shorter notice period. The notice does still need to expire at the end of a rent period or the first day of the next, unless the landlord agrees to waive some of the notice period. So do check the tenancy agreement to see whether there's a shorter notice period than 2 months, and if so, the tenant will only need to give that shorter notice period. So what does a notice to quit look like? It can be very simple, and I have an example in my blog post, independentlandlord.com/NTQ. Tenants need to tell landlords formally that they wish to end a tenancy agreement. It needs to be in writing, and it must be for the correct notice period. And when I say in writing, tenants can serve a notice to quit by a letter, allow plenty of time if you do, email, and the government guidance says that you can even do it by text. But if you're a tenant, it is best to send it by a hard copy, as well as email and text, just to make sure that your landlord or your agent has received it. When must a tenant notice to quit expire to be valid? Tenant notices to quit are subject to the common law rule that the notice must expire at the end of a rental period or the following day. And this hasn't been enshrined in statute, but it is still binding, which means that the tenant should give at least 2 calendar months written notice to the landlord to expire at the end of the rent period or the first day, unless, of course, the tenancy agreement says there's a shorter notice period, like 1 calendar month. Can a landlord agree to a shorter notice period? Well, yes, a landlord can always agree to a shorter notice period, either in the tenancy agreement or in a separate document. However, if there's a joint tenancy with more than one tenant, all of the joint tenants must agree to a shorter period, and this can be in the tenancy agreement or in a separate document. I'll get on to joint tenancies in a bit more detail in a minute. So can tenants withdraw a notice to quit? Yes. Before the Renters' Rights Act, they couldn't, but now they can, as the Renters' Rights Act contained wording that said it can be withdrawn before the date on which it takes effect if the landlord and the tenants agree in writing to the withdrawal. So let's talk about joint tenancies. What happens if one joint tenant, like a sharer, serves a notice to quit? Notices to quit are far more straightforward if it's just a single person or a couple and they both want to leave. But it's a lot more complicated if you have more than one person on a joint tenancy. So what is a joint tenancy? A joint tenancy is a single tenancy agreement that's signed by two or more tenants who together share the same rights and responsibilities for the property. And so each tenant is named on the tenancy agreement, each of them signs it, and each of them becomes a tenant for the whole property that they're renting. This is different from where they rent a room and have their own tenancy agreement separate from the person who rents the room next door. With a joint tenancy, they share the same responsibilities to pay the rent and to look after the property as if they were just one person. Their liability is said to be joint and several, which means that the joint tenants are each responsible 100% and also jointly responsible for all of the obligations under the tenancy, including paying the rent. So if one joint tenant serves a notice to quit, it will bring the tenancy to an end for all of the joint tenants, even if the others wish to stay. And the person giving the notice doesn't need the consent of the other tenants before giving the notice. And so this is a long-standing rule and it predates the Renters' Rights Act, and Renters' Rights Act did not change that. If the remaining tenants wish to stay, the landlord will need to enter into a new tenancy agreement with them. And they'll also need to deal with the deposit for the old tenancy and protect a new deposit for their new tenancy and deal with inventories, etc., etc. So if a joint tenant wants to agree a shorter notice period with the landlord or even withdraw it, all of the joint tenants and the landlord need to agree. And if a sharer wants to leave, it would be possible also for them to surrender the tenancy, and the others would then remain liable for the whole rent. Another tenant could be added as well. However, it's far simpler to have the tenancy end when a tenant wants to leave and enter into a new one for the remaining tenants and any new tenants that join them. You'll then have to deal with the deposit, and it's good practice to have a thorough inspection to make sure that the condition of the property is clear when the replacement tenant arrives. So what should a landlord do if they receive a notice to quit from a tenant? First of all, a landlord should check whether or not the notice to quit is valid. And so here's a little checklist to see whether or not it's valid. First of all, is it notice in writing? The notice to quit must be in writing. It just can't be a tenant saying, I want to move out. They have to write it down. And as I mentioned before, the definition of writing is very wide and includes letter, email, or text. A landlord cannot insist on a particular method. For instance, they can't insist it's a letter, and they have to accept anything that's in writing. The next thing is to check whether the notice to quit gives the right amount of notice and the correct amount, which will be at least 2 months under the Renters' Rights Act, aligning with the end of a rent period, unless the tenancy agreement provides for a shorter period. So check the tenancy agreement to see if there is a shorter period. And any clause asking for longer than 2 months will be null and void and will be substituted by the 2-month cap in the Renters' Rights Act. And next thing, check whether the notice expires at the end of a rent period or the first day of a rent period. For instance, if the start of a rent period is on the 26th of each month, the notice needs to expire on the 25th or the 26th. The next thing is to acknowledge receipt in writing. Although it's not a strict legal requirement, the landlord or agent should confirm receipt and state when the tenancy will end and explain what the arrangements are for doing an inventory and handing back the keys. A short written acknowledgement also creates a record of the end date for the return of any tenancy deposit and for the purposes of council tax. The next one is to let any joint tenants know. So if the tenant who gave the notice is a joint tenant, write to the other tenants to let them know that their fellow tenant has served notice to bring the tenancy to an end. They might not know. But what happens if the tenant doesn't give enough notice? The rules are quite complicated. It remains to be seen what the courts will decide, and whether the notice will still take effect from the end of the next rent period that meets the 2-month requirement or lower amount in the tenancy agreement. Nevertheless, I would contact the tenant and explain to them that they didn't give the correct amount of notice and ask them to reserve the notice with the correct date. As for what is the right thing to do, it depends on the circumstances. For a long-term tenant in a single let, I personally just ask for 1 calendar month's notice to expire after 1 calendar month, and I don't mind if it doesn't coincide with the end of a rent period. However, if the tenant hasn't been there for very long, it might be appropriate for the landlord to insist on a full notice period. Now, notices to quit are just one of the many areas where the Renters' Rights Act has changed the way we operate. And for the full overview, do take a look at my book, The Good Landlord Handbook, which goes through the rules for every stage of the tenancy. And you can find it on Amazon. And don't forget that you can sign up for my free weekly newsletter to keep up to date on theindependentlandlord.com/subscribe. If you need any extra help and you've got questions, you can join my community, the Independent Landlord Hub, where you can ask me questions at the monthly live streams. See you soon, and hopefully in the hub.